The big new addition to this bill is warrantless searches by police.
Every time the police suspect you of a minor crime, are they allowed to follow you into your house without a warrant?
Tonight, outrage over proposed legislation that many Oregon gun owners say is sweeping and unconstitutional.
If you ask what is unreasonable, it is a writ of assistance or a total fishing expedition search.
The officer did not have a warrant, but claims he was in, quote, hot pursuit of the suspect.
Some of them, maybe 2 or 3, seem to think, well, why not get a warrant?
Supreme Court decision. All right, let's dive into this hot topic. The Supreme Court's recent unanimous decision on firearm confiscation, specifically focusing on warrantless searches and seizures happening right in people's homes. Now, this decision is a big deal, not just for legal buffs, but for all of us who care about our rights and safety. First off, imagine this. You're at home, minding your own business, when suddenly the police show up without a warrant and start rummaging through your stuff, specifically eyeing your firearms. Pretty intrusive, right? Well, that's exactly what's at stake here. Understanding the implications of this Supreme Court decision is crucial because it directly impacts individuals and communities across the country. It's not just about legal jargon, it's about our fundamental rights as citizens. See, the Fourth Amendment protects us from unreasonable searches and seizures, including in our homes, but when it comes to firearms, things get even trickier. Now let's talk about how this whole concept of warrantless search and seizure affects gun owners. Picture yourself as one. You've got your Second Amendment rights to bear arms, but now you're wondering if those rights are at risk when the government can just barge into your home and take your firearms without a warrant.
The big new addition to this bill is warrantless searches by police.
Past week, the Supreme Court heard oral arguments in Lang versus California.
If you ask somebody about the Fourth Amendment, they're going to tell you that it's all about stopping unreasonable searches and seizures.
The officer did not have a warrant, but claims he was in, quote, hot pursuit of the suspect.
It's a sticky situation because on one hand, we want to ensure public safety and prevent harm, but on the other, we also want to safeguard our individual freedoms and privacy. And that's where the Supreme Court comes in, to strike that delicate balance between security and liberty. So what does this decision mean for gun owners? Well, it's a reminder that our rights aren't set in stone. They're constantly being tested and redefined by the courts. It's also a call to action for communities to stay informed and engaged in these legal debates, because at the end of the day, it's our voices that shape the laws that govern us. In essence, this Supreme Court decision isn't just about firearms, it's about the very essence of our democracy, the balance between security and freedom. So let's keep an eye on how this unfolds, and remember that our rights are worth fighting for, no matter which side of the debate you're on. Case overview. Buckle up, folks, because we're about to embark on a journey through the legal landscape of 2 intriguing cases, Conegliov-Strum and Tevye versus Suff County. Get ready for some courtroom drama. First up, let's meet the players in Conegliov-Strum. We've got Mr. Caniglia, a homeowner whose firearms were confiscated without a warrant. The legal argument here revolves around whether the police had the right to enter his home and seize his guns without proper authorization. It's a classic tale of individual rights versus government authority. Now on to Tevye versus Suff County. Meet Wayne Tevye, just your average guy whose firearms were also seized without a warrant. The twist? It all started with a false complaint from his granddaughter. The legal question here is similar to the Caniglia case. Did the police have the right to enter Tevye's home and confiscate his firearms without a warrant? Now let's break down the similarities and differences between these 2 cases. Both involve warrantless searches and seizures of firearms, which is enough to get any legal eagle's feathers ruffled. However, the circumstances surrounding each case are unique. Caniglia's situation stemmed from a domestic dispute, while Tevye's began with a false complaint.
The case asks whether a police officer violated the Fourth Amendment.
If you ask what is unreasonable, it is a writ of assistance or a total fishing expedition search.
Give me a sense of the political implications on policing, on privacy, and the Fourth Amendment.
Perform warrantless queries where the search is reasonably likely to retrieve foreign intelligence information.
Despite their distinct beginnings, both cases raise fundamental questions about individual rights and government authority. They force us to ponder the limits of law enforcement power and the importance of safeguarding our constitutional protections. So what's the verdict? Well, that's where things get interesting. While the legal arguments in both cases may seem cut and dry, the outcomes could have far-reaching implications for our rights as citizens. It's a legal showdown that's sure to keep us on the edge of our seats as we wait to see how the courts rule. False complaint and subsequent events. Let's delve into the whirlwind of events that led to the case of Tevye versus Suffolk County. It's like something out of a legal thriller. It all began with Wayne Tevye, just your average Joe going about his day, when suddenly out of nowhere, his teenage granddaughter made a false complaint to social services. Now, we don't know what sparked this complaint. Maybe it was a teenage tantrum, or perhaps there were deeper issues at play. Regardless, the complaint alleged that Wayne was acting strangely and yelling at her. Little did Wayne know, this complaint would set off a chain of events that would land him in the middle of a legal storm. Enter law enforcement. Upon receiving the complaint, social services reached out to the Suffolk County Police Department, who wasted no time sending not one, not two, but 3 officers to Wayne's doorstep. After assessing the situation, the officers found no evidence of any wrongdoing on Wayne's part. In fact, they concluded that the granddaughter's complaint was entirely baseless, a false alarm. But here's where things take a turn for the worse. In the midst of their visit, one of the officers accidentally knocked down a magnetic drape attached to Wayne's front door. As Wayne bent down to pick it up, the situation escalated when the officer became aggressive, threatening to tase Wayne and accusing him of wanting to die. Wayne, understandably alarmed, mentioned his heart condition, but the officer misinterpreted his words as a desire for self-harm. Before Wayne knew it, he was handcuffed and whisked away to a psychiatric hospital for an emergency evaluation. And that's when the nightmare truly began. While at the hospital, it was discovered that Wayne had a New York State pistol license, leading law enforcement to believe that he also owned firearms. Without skipping a beat, they contacted Wayne's wife and pressured her to hand over the combination to their gun safe. Despite their initial refusal, the pressure mounted, and eventually they relented, fearing that Wayne would be stuck in the hospital indefinitely. Warrantless searches and seizures. Let's roll up our sleeves and dive into the legal nitty-gritty of warrantless searches and seizures. First things first, we need to talk about the Fourth Amendment, the unsung hero of civil liberties. This bad boy protects us from unreasonable searches and seizures by the government, requiring them to obtain a warrant based on probable cause before rifling through our stuff. It's like our personal shield against government overreach.
Every time the police suspect you of a minor crime, are they allowed to follow you into your house without a warrant?
They were looking for a way to limit that power. So they wanted no writs of assistance.
Some of them, maybe 2 or 3, seem to think, well, why not get a warrant?
Every time you go into your house, if the police are following you, that's hot pursuit, and the police shouldn't have to get a warrant.
Now, let's zoom in on the Supreme Court's rulings on Kongliov.Strum and Tevye versus Suffolk County. In Kongliov.Strum, the court unanimously ruled against warrantless searches and seizures of firearms, emphasizing the sanctity of the home as a protected space. This decision was a win for individual rights and sent a clear message that the government can't just waltz into our homes and take our guns without due process. But hold on, because Tevye versus Suffolk County takes us on a roller coaster ride of conflicting rulings. While the facts of the case are similar to Kongliov.Strum, warrantless seizure of firearms, the outcome is a head-scratcher. The Second Circuit Court of Appeals upheld the warrantless seizure in Tevye versus Suffolk County, ignoring the precedent set by the Supreme Court in Kongliov.Strum. Talk about a legal curveball. And that's where the plot thickens. When lower courts start playing fast and loose with legal precedents, it creates a legal minefield for us all. Suddenly, the rules of the game become murky, and the line between lawful and unlawful blurs. It's like trying to navigate through a maze blindfolded. You never know what's around the corner. Uncertainty in legal landscape. Let's dive into the murky waters of legal uncertainty and its impact on gun owners, especially in the context of red flag laws. Strap in because things are about to get complicated. First off, conflicting legal rulings and interpretations create a breeding ground for uncertainty. When lower courts can seem to agree on the interpretation of the law, it leaves us all scratching our heads, wondering what the heck is going on. It's like trying to navigate a maze with no map. Frustrating, confusing, and downright nerve-wracking. Now let's talk about what all this legal chaos means for gun owners. With conflicting rulings flying left and right, gun owners are left in a state of limbo, unsure of their rights and responsibilities. On one hand, they have the Second Amendment protecting their right to bear arms, but on the other hand, they're faced with the looming threat of warrantless searches and seizures. It's a catch-22 that leaves them feeling like they're walking on eggshells.
Tonight, outrage over proposed legislation that many Oregon gun owners say is sweeping and unconstitutional.
The Supreme Court is suddenly getting very modern. How did this case get to the court?
They conducted a classic modern writ of assistance search. We all understand that.
The police are following a bunch of scared teenagers, and the teenagers go into their own homes. The police should be able to go into their homes without a warrant.
Enter red flag laws, the elephant in the room when it comes to gun ownership. These laws allow for the temporary confiscation of firearms from individuals deemed to be a danger to themselves or others. Sounds reasonable, right? Well, not so fast. With conflicting legal rulings muddying the waters, red flag laws become a double-edged sword. On one hand, they can be a tool for preventing violence and protecting public safety, but on the other hand, they can be used to trample on the rights of law-abiding citizens, leading to unjust confiscations and violations of due process. So, what's the bottom line here? Navigating the legal landscape as a gun owner has never been more challenging. With conflicting rulings and the specter of red flag laws looming large, gun owners find themselves caught in a legal minefield, unsure of where to step next. It's a daunting task, fraught with uncertainty and potential consequences. That's all for this video, folks. See you next time.